Okay.
Announcement is made that adequate notice of this meeting has been given and that it is being conducted in accordance with NJSA 10:4-6 et sec of New Jersey Open Public Meetings Act. Nora, would you call the roll, please?
Mayor Barbario.
Here.
Mr. DiPiero.
Here.
Ms. Hernandez.
Here.
Mr. Mealy.
Here.
Mr. Meth here? Nope. Mr. Napolitano.
Here.
Mr. Shaw.
Here.
Ms. Smith.
Here.
Chairman Dinsmore.
Here.
We also have our board planner, Ms. Winter, our board engineer, Mr. Canjiano, our board attorney, Ms. Steinley, and our special guest, the town planner, Mr. Snikes.
If we could say the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America, to the republic for which stands one nation, under God, indivisible, with liberty and justice for all. All right, this meeting is open to the general public. Is there anyone here that wishes to address this board on any subjects not on our agenda tonight? Hearing and seeing none, we have only one item on our agenda, and that is the housing element and fair share plan. Counselor.
Good evening, board. Okay, good. Dustin Glass from Semiraro and Farney. Our firm is the Township's Affordable Housing Council. We're here tonight. The board's already been presented with an affordable housing plan. This is to comply with the Fair Housing Act and the fourth round obligations. The planning board's charge tonight is to review and then would adopt the housing element of the master plan, which would then go to the governing body for an endorsement thereafter. The fourth round of the Fair Housing Act requires that a municipality, it has a variety of dates and deadlines, many of which have passed. The next one is that a municipality must adopt its housing plan on or before June 30th of this year, and then file that with, I'll say, the Superior Court and the Affordable Housing Dispute Resolution Program within 48 hours. Participating in the process, I'll just say in good faith, and continuing to do what's statutorily required permits the municipality to maintain its immunity from builder's remedy lawsuits. So participating in the process and at this point in time adopting a plan is what is needed for the township to maintain its immunity. You'll hear from Ed Snikes, who will present the plan, provide an overview. We're here to answer any questions. I think it's important to remember that the fourth round is a 10-year long process. So to the extent there are projects in here that are to be constructed, they're not popping up tomorrow, they're not popping up the next day. Yes, it'll be over a period of time, and yes, there's impacts to the community, but they're nothing immediate. You know, they take time to occur. And I think, as you'll see by the plan, there's a reasoned methodology as to how the units were allocated, and Ed will walk you through the process as to the number of units that the township is satisfying, how we arrived at that number. Well, I guess I could tell you a little bit about that. Just for brief discussion, the Department of Community Affairs issued numbers throughout the state that there were the affordable housing obligations, at least whether they were presumptively valid or whether they were just guidance, I guess, is to be debated, but municipalities were free to offer differing numbers based on their analysis of the statute and the vacant land available in their municipalities. In this case, the DCA had calculated 553 affordable units for the fourth round new construction need, I'll call it, prospective need. The municipality submitted for 496, and Ed was able to review and find parcels that the DCA had included that, I'll just say for lack of a better way of putting it, should not have been included or not developable for a variety of reasons. And the court, after mediation, or the township did receive a challenge from the Builders Association, which is I'll just call it a trade group, I guess, that represents builders associations throughout the state. Take it for what it's worth. Mediation was unsuccessful, but the program eventually sided with the township, dismissed the builder's challenge, and agreed to the 496 number. This plan is here to address the 496 units, and I think with that, I will stop talking and turn it over to Ed Snikes.
Thank you very much. Everybody hear me okay?
And I'll just swear you in, Ed.
Yeah.
Can you please raise your right hand? Do you swear or affirm that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And could you just please state your license and background for the board?
Absolutely. The name is Edward Snikes, Jr. I'm with the firm of Burgess Associates in 25 Westwood Avenue in Westwood, New Jersey. I have a license in professional planning and also a license in landscape architecture in the state of New Jersey. I was the author of this document, and I will be providing the presentation associated with it. We've been retained as your affordable housing planners for this document in concert with the overall township, and we are submitting this document to the planning board for consideration this evening for potential adoption. And what this document becomes is actually an element of your master plan. It's a required element under the municipal land use law, and it's a component that we currently have a housing element and fair share plan. But that fair share plan is about to sunset on June 30th, very soon. And because we were given an approval by the court based upon that third round plan up until June 30th of 2025. And so that's why the state back in 2024 had prepared new rules associated with this next round. It's called the fourth round. We've gone through the first 3 rounds already, and we're now in the 4th round of the Housing Element and Fair Share Plan. I do have a PowerPoint presentation that I'm referring to for the record. Also, I'll be referring to in the documents dated June 12th, 2025, and it has been on file minimally 10 days prior to this meeting. Included in that, we also did a notice to surrounding municipalities, as well as we did send copies to the state and to the county planning board in accordance with the regulations, since it is an element of the master plan. And so with that, I'll go through this presentation. And as Dustin had touched on, the effort here is really to address the issue of affordable housing within the community. And what we're trying to do is maintain protections from what's called developers remedy lawsuits. Those are actions that could be taken if, in fact, we didn't affirmatively address what the state has assigned to us as the allocated need for the 4th round. And so we're trying to maintain compliance with the doctrines and with the rules that have been established. I'm just going to go through some quick background that we prepared just in case there's people in the audience that are not aware of this information. First off, there was Mount Laurel 1, Mount Laurel 2, starting from 1975, taking us to 1986, wherein the New Jersey Fair Housing Act was affirmed, and its validity was affirmed at that point in time. In addition to that, the New Jersey Housing Act created COA, Council on Affordable Housing. The Council on Affordable Housing was a former agency. It no longer exists, but that agency of the state was assigned to prepare rules and also obligations for municipalities. It required a housing element and fair share plan to be adopted by all municipalities. In addition to that, they established what were called the 1st and 2nd round rules. So COA did all those components as part of an agency of the government. And then in addition to that, Parsippany-Troy Hills prepared 1st and 2nd round plans, and they were certified by COA. So Parsippany and the township itself has a long history of complying with the affordable housing requirements of the state. And that's something that I think we should be proud of and be recognized for as we move forward. Included as well, we also prepared a 3rd round plan. And we petitioned COA when COA was still in effect at the time for that plan to be certified. On 2 occasions, we actually submitted those documents. At that point in time, though, COA and the statewide rules were challenged and determined to be non-compliant. At the time, there was an issue called growth share that was being considered as part of the rules. If the municipality grew, it would have to add affordable housing. That was overturned because it was not specifically identified in the Fair Housing Act. And so therefore, we now have something called fair share. And fair share is a methodology by which the affordable housing need is distributed to various communities, all communities throughout the state, with the exception of urban aid communities. Urban aid communities are exempt from that distribution. And so we, as a municipality, receive that allocation of the numbers, and those numbers are based on several factors. COA's 3rd statewide rules were challenged, determined to be non-compliant. Fair Share Housing Center then also had sued the state and then on March 10th in 2015, the New Jersey Supreme Court decided what was called Mount Laurel 4, another action of Mount Laurel, where in fact it was determined that COA was ineffective and they were trying to create these new rules based upon fair share, but that the courts realized that it was going nowhere. And so therefore, they pulled the responsibilities back to the court. And so actually municipalities that wanted to get protection from affordable housing lawsuits or builders remedy lawsuits needed to submit a petition to the court to get their plans certified. So it restates that the court is that forum instead of COA. Just real quickly, if we don't act, and I just wanted everybody to be aware of this, there has been many examples of where municipalities have lost control of where affordable housing can go. And one, in fact, that I'd mentioned to you, and it costs a lot of money through legal fees and things of that nature. No offense to the attorneys in the room, but it takes a lot of litigation and discussion about it. South Brunswick is a prime example where Judge Wolfson, back in 2016, he ruled that the township was not proceeding in good faith, and so therefore withdrew their immunity from builders remedy lawsuits, and the court actually took over in concert with Fair Share Housing Center, as well as the court master and builders, to decide what their housing plan would be. And so that itself caused a lot of issues associated for that township. And just as an example, it's not meant to scare anybody, but it's just that that's the reality. It's the reality of why we need to prepare a plan and pursue a plan in order to maintain conformance with the appropriate rules. In addition to that, we did, in the third round, we entered a settlement agreement back on April 11, 2019. Judge Gauss was our judge that reviewed our settlement agreement and approved that settlement agreement on July 24th of 2019. All this is to show you and show the roadway that we had actually gone down in order to maintain control of our zoning. The total need at that point was 1,314 units. That was a very substantial number. So we pursued something called a vacant land adjustment. And from a vacant land adjustment, you look at the available lands that are available for development. And then you also then factor in environmental restrictions, whether there be deed restrictions on specific pieces of property, things of that nature. But that at that time, we also were required to consider certain interested parties that were interested in being part of our housing plan, that were also indicating that they would build affordable housing as part of their developments. And that was something that we were required to consider as we went through mediation with the court-appointed master at the time. And at that point, we established a RDP, or from the vacant land adjustment, of 735. So a reduction from 1314 to 735 for the third round. That left an unmet need, what's called an unmet need, which is the remainder, after you subtract 735 from 1314, of 469 units, let's say, that were still remaining. We did actually have to first affirmatively address the 735. You'll see in a moment, I'll be going backwards a little bit in time to show how we did so. And then also, we also adopted overlay zones to capture units associated with unmet need, in order to show that we were positively addressing unmet need. You're required to address your entirety of your RDP, but you're not required to address your entirety of your unmet need. You just to show an effort to address the unmet need. Under the third round housing plan, Judge Gauss also approved the housing plan back on December 10th of 2020. There were several projects approved and then also under construction since that housing plan, as this board well knows, as well as others. And then some have been zoned, but remain as zoned. Moving forward now into the fourth round need allocation. Back, as I mentioned a moment ago, last year, around March 20th of last year, there was an amendment to the Fair Housing Act. I'll be referring to that amendment as FHA 2, or Fair Housing Act 2. It identified that COA was no longer effective, and it abolished COA from an agency of the state. And it created a new process and a new entity that was associated with the what's called an Affordable Housing Dispute Resolution Program. And it's associated with the Office of the Court, and it is signed under the Fair Housing Act 2, as Dustin mentioned a moment ago, that DCA, Department of Community Affairs, was then charged with establishing what the need should be. And then at the time, there was also an identification that the Jacobson decision, which was a case that was ruled by Judge Jacobson down in Mercer County between West Windsor, Princeton, and Fair Housing Center, wherein they debated over many, many meetings the actual rationale to establish what the need would be. And that decision has effectively been carried forward. It's been ruled effective, and that decision established the process to go about how to distribute the need. DCA followed that model from the Jacobson decision and then distributed the need to the various communities. I would say that, and I don't want to be accusatory in any way to DCA, but they had very limited time to prepare their allocation of need. And as Dustin mentioned a moment ago, we did find some fault and some errors in their calculation for the land capacity factor. There were 3 factors that were part of their analysis. The land capacity factor, there's also the non-residential valuation factor, as well as the income capacity factor. Those 3 factors get factored together, no pun intended, to be calculated as where, in fact, need would be distributed overall. First, the need is established statewide. There was about 84,000 units that were estimated in need for the next 10 years by these calculations. And then from that need, they then use the Jacobson methodology to distribute the need to various municipalities. So we did review that information. Let me just fast forward to follow along my outline. Fair Housing Act 2 also identified how that calculation is done. And then that calculation is in 2 parts. One part is called prospective need. That's the new construction that Dustin mentioned a moment ago, obligation. There's also a present need obligation. And what present need, the difference is the present need obligation, I would consider that as rehabilitation of existing units. We currently have a very successful rehabilitation program that we've been conducting throughout many years, I think since the 70s, using CDBG grant funding to help upgrade homes, whether it be their critical systems, roofing, heating, things of that nature have been improved in certain homes. And we look to continue to do that, but what's been estimated is that we have additional need going forward in the next 10 years for that. And I'll touch on the numbers in a moment. Real quickly, what qualifies as low and moderate, or moderate and low and very low income? We are in a region, a housing region that was established during COA. That is a housing region called Housing Region 2. It consists of Essex, Morris, Union, and Warren counties. And in those counties, that the numbers are calculated every year as to what are the income qualified individuals. Just for reference, you can see that moderate income is you can make up to $75,000 a year in 2025 for a one person, whereas low is 47,000 and very low is 28,000. The reason why there are those 3 levels of income is that there are various unit types that are required by the rules, have to be established within these affordable housing developments. And this just gives you a snapshot as to what some income levels are. And this is provided also in the Housing Element and Fair Share Plan draft that this board is reviewing. Next slide. Excuse me, got that animation. DCA in the 4th round in October 2024 had distributed the need under what I just mentioned a moment ago as present need. We have 138 as projected from census data that the state has used to compile what the present need is. We didn't actually have any dispute over those numbers because we reserved our rights to reevaluate those numbers. And you do have a right under the rules to reevaluate that, doing what's called the windshield survey. You can go around to the various neighborhoods and evaluate whether or not we feel there is 138 or not. But yet we are still putting in a program in the overall housing plan to try to address some of that need, whether it be real or not. Our prospective need was assigned, as Dustin mentioned, at 553. We sought and received a reduction down to 496. The court set it at 496 on May 13th of this year. Many will be surprised by the 496 unit affordable requirement, but I wanted to point out that there are not only Parsippany is subject to this. What we're seeing throughout Morris County is that there are a number of municipalities that are 400 or more. In fact, there are some close to 1,000. We have Roxbury Township at 989 units that they have as a need number. In addition to that, we have in Bergen County, Paramus, the borough of Paramus is 1,523. They are capped at 1,000 units, but yet still 1,000 units is a lot of affordable units. Edison Township, 727, South Brunswick is 959. Wayne Township was 1,746, but they also have a 1,000 unit cap based upon the rules. So that just gives you an idea of where we are within the context of other communities. So it's not just within Parsippany, it is actually within our region as well. So where we are right now in the schedule of time, unfortunately, and I say unfortunately only because it really required a lot from planners as well as administrators at the municipal level in order to prepare housing elements and fair share plans. It was a very short time frame. We had October 24th where the numbers were actually distributed. We had until January to determine whether or not those numbers could be adjusted. February 28th, there was the challenge period at which the courts were reviewing the challenges. But also, as I mentioned, by May, we received actually a final determination. So from May to now, we actually had to formulate a plan and get it submitted and reviewed in order for us to have this meeting tonight to potentially adopt the document. What would be the next steps is that we would have on July 1st through August 31st is a plan of challenge. That's where challenges can occur to our plans within that 2-month time frame. Those challenges would occur at the state level. They would be accepting any challenges to our housing element fair share plan, and then we would get into mediation there after that point. But yet, you'll see in a moment that we wanted to prepare a very defendable plan that addresses our need. It's a very statutorily appropriate plan, so we feel very confident that it should survive challenges. March 31st would be the time frame wherein any implementing ordinances would have to be adopted. You'll see in this element of the master plan, there are some recommended draft ordinances for some of the zoning areas that we're proposing. And those are draft ordinances at this time, meant to be placeholders that are reflective of the actual developments that are being considered for those locations, but that they would be further refinements to those. And you'll see them as a board before they get adopted. So with that, I'll transition into the review of the prior and third round. And the reason why we're going backwards in time is that it's required by the rules. You have to look back to see how your programs all did in the prior plans, to see if there's any gaps that would have to be addressed. We did not have any gaps in the prior round. We have addressed all of our 664 unit obligation from 1987 to 1999. Many of the projects have been completed with some approved as well. So that's the prior round plan. Oops, sorry, I meant to advance the slide. I'm sorry if you can't see this from a distance, but it's part of the plan document itself. The next step was to look at our third round plan. We have a 845 unit obligation between 1999 to 2025. That 845 unit obligation of RDP has been also affirmatively addressed, although I will identify for the record that we did have 2 locations where we had zoning for inclusionary housing. They were located on Edwards Road. What has come to pass, as Dustin mentioned a moment ago, is new rules based on DEP changes to their inland flood requirements. And those 2 projects or those 2 locations where we established zoning for affordable housing are no longer practical because the flood elevations have changed and they now are not providing affordable units. So the net effect of that is that we do have to find affordable units to address that gap in the need. In addition to that, we also had a market to affordable in the prior round that we had as part of our planning. And in that, we had established the program, but it never got off the ground. So we do have to make up for that program. But I did not want to leave us vulnerable to that program in the third round. So I chose to move credits associated with other successful developments that we had in our plan. And one successful development that you have in your plan that's actually under construction and people have started to move into the development is Park, which is the former Lanadex project. If you remember, that had 120 affordable units as part of that development approved. So that development, those 120 units, we look to apply 74 of those 120 units to the third round need of 845. And the effort there is to address that gap in the need. So therefore, we've affirmatively addressed that gap and now have shown that we addressed that condition. In addition to that, we had several other projects, including prior cycle credits. We had prior cycle alternative living arrangements as well, senior units that we applied to the third round. Also built and approved developments. We had 700 Mountain Way, Palmar Associates. Also, we had one Habitat for Humanity project that we included in the plan. Also, inclusionary developments such as Stanbury, the McCallie Avalon project, Westmount Plaza was also part of a rezoning that we did. Park, as I mentioned, and Weicker, on Johnston Road, sorry. And then Lika, which has gone under many names, but it was always as SJP Morris Corporate Center, was also part of the plan. Sorry, these are not readable, they were in my office. But yet, they are in the plan under the tables that are provided for the third round. In addition to that, we had some proposed alternative living arrangements that have been completed. There are a series of 5 that also give us credits, but that I wanted to identify that of that third round, we actually had 634 actual units be approved and part of that plan, but yet took benefit of 211 bonus credits. That may sound a little unusual, bonus credits. What the bonus credits are is that you're allowed for certain types of developments, whether it's a rental, whether it's a group home type development, you get certain bonus credits associated with those types of developments that you can apply. And so therefore, that 211 plus the 634 makes up for the 845 need that we need to address between 1999 and 2025. So now to the fourth round. So we've now affirmatively addressed the prior and third round. So now we're looking at the fourth round. So within the fourth round, again, we went back to look from the third round to the fourth round, how the community has done from the standpoint of what areas are available for potential development. And the mechanism of vacant land adjustment is something we look back to. And as you well know, we are now a conforming municipality to the Highlands. So we use the Highlands build-out analysis as the tool to evaluate any vacant and developable land. We went to the portal for the Highlands, used the portal at the Highlands to review vacant land within the community. And I'd like to report that you don't have any additional land that I didn't already identify in the third round. So there was no additional vacant land that is adding to your RDP from the third round. What that does not recognize, though, is that there are requirements under the rules to look at potential developments that are willing to be part of your plan. Under the Fair Housing Act, there's a section in the Act that calls out that existing structures most appropriate for conversion to or rehabilitation for low and moderate income housing, including a consideration of lands of developers who have expressed a commitment to provide low and moderate income housing. The reason why I read that into the record is that's the rule by which we need to recognize certain interested parties or entities that might be interested in being in our plan. So from that statement, we did have to consider a number of potential entities that were interested in being in our plan. We had a need number of 496, even though we were still at an RDP that was already addressed. We do have this 496 number that we still have to affirmatively address. So the township with limited vacant land was required to review these sites. We received numerous willing sites for development requests. We reviewed the planning rationales, goals, and objectives of the master plan, as well as the Highlands Regional Master Plan. And we recognized that not all were appropriate in where they were located. So we did deny certain requests. It was apparent, though, that we had ample developments to address locations that exist to address the allocation of 496 units. So therefore, we have reduced consideration to 7 sites within our plan that we're proposing to the board for consideration. They're either vacant or underutilized or unused sites that are currently developed within your community. And what's unique about that situation is that because they're currently developed, they often fell within locations that were already within the Highlands Master Plan, recognized as environmentally, I was going to say environmentally constrained zones, but it's not. It's actually developed areas within the community. And I'll remember the acronym in a minute. But that statement or that identification was recognizing the existing developed condition. Many of them are office buildings. There's other commercial properties. One of them is a vacant lumber yard that's being considered. So as you can imagine, the master plan, at least at the Highlands level as well as our level, recognize those sites as commercial development, but that they were not environmentally constrained from the Highlands master plan in that regard. We then looked at whether or not the sites were considered for redevelopment. Some were, as part of the overall redevelopment scheme that has been identified within the municipality, as well as many would benefit from adaptive reuse. Many were adjacent to major highways. Also in your zone plan, they were maybe more appropriate than other locations, as well as their geographic distribution was also considered in establishing the numbers and the consideration of specific properties. And I just found the actual section that I was hoping to find. It's the existing community zone, but also some are also located in what's called your lake community zone. And it had to do with proximity to the reservoir, the properties adjacent to the Booton Reservoir. They're not, in my opinion, I'll show you in a moment, one of the properties is on the opposite side of Route 287, so it's not a directly adjacent property, but yet, as they establish setbacks or offsets from certain water bodies, the Highlands did put it in the lake community zone. No locations were in an environmentally constrained subzone, and many, as affordable housing, provide consistency with the Highlands Regional Master Plan. We also reviewed from a water standpoint their demand for water. As this board will likely remember, is that in the prior round plan, there was a scarce resource order that was exhibited or established for the community. We then went through and looked at what availability of water there was. We have a very successful water improvement program that improved our wells, improved capacity, and our systems. It addressed the scarce resource order that was removed in 2020, and that since that time, we have been submitting reports to show how our improvements have been made to our water system. And from estimates based upon the number of units that are being proposed, we find that there is still capacity available in the water system. In addition to that, we also looked at locations, and as I mentioned, where they were adjacent to new roadways, or excuse me, existing highways and roadways, where traffic patterns will occur, and had compared them to realizing that the existing properties were also currently developed for non-residential uses. We also looked at the specific zoning requirements and established a draft, as I mentioned, in the document. We also reviewed that and recognized that these will all be subject to a full site plan review, all of these properties that we're recognizing and identifying for the plan, for on and off-site impacts, as well as fair share improvements, as well as part of those developments. So looking at the fourth round, addressing the 496 units, there are 7 different properties that are recommended in the plan. The first one is 4 Gate Hall. Its location is currently an office building. We are recommending that that be part of a consideration for affordable housing. That property is located in the ROL zone. Also, we have the Park Lanadex project. They're asking for increases in density. If you recall, there was the prior zoning for a portion of the existing office development that's there. What we're offering is that they are interested in expanding that project, making it much more of a comprehensive center, still maintaining a mixed-use aspect to that development, but also increasing residential density in that location. There will be a need for further traffic improvements for that project. They do have that in their phasing schedule to make certain improvements to accommodate the additional development. There's another project called the Bixmore redevelopment. That's the mixed use at the Parsippany Plaza. I think that's what, Marcel's Plaza, thank you, Dustin. That development has an existing movie theater that has a redevelopment area being considered for it. That, I feel, is a prime opportunity to do a new mixed-use center, right there on Route 46 and adjacent to other similar uses, as well as its proximity to goods and services at that location. The next one is on Parsippany Boulevard. The Embassy Suites is interested in converting the building, the existing building, into a inclusionary development. We would have market rate as well as affordable housing as part of it. That would be something considered as an adaptive reuse of the existing building. I find that as an interesting proposal, especially with the indoor atrium space that's inside that development, providing some amenities for future residents. And it provides an opportunity to have some residential closer to some other goods and services that are provided on Route 46. 400 Interpace. That is a location wherein there are existing office buildings. There is a proposal to convert and remove one of the office buildings and part of the parking area, but to establish a multifamily residential development at that location. The next one is at Upper Pond Road. That is also a development that is currently an existing office development. What's proposed there is to do stacked and conventional townhouses at that location. That would be a conversion of, I think it's 3 office buildings there, whereas a total of 6 in total on the entirety of the property, but 3 office buildings would be replaced. And then it would create sort of a mixed-use area as well at that location. The last one is on Route 46. It's the former Serbo Lumber property. That is a recommendation for a multifamily residential development at that location. So within each one of these developments, they provide 20% of their overall number of units will be affordable. And that would meet all the affordable housing regulation requirements. And with that, it allows us to apply, again, bonus credits to this round. And the bonus credits are permitted to be a maximum of 25% of the need that is being addressed. What we're proposing is to address the entire of 496, and so therefore, you can take credit for 124 bonus credits associated with that 496. So in net, the number of affordable units being developed by those 7 projects would be 372 units of credit of affordable units in those 7 projects. With 124 bonus credits, that adds up to 496 total units. Therefore, that would address your entire 4th round need, which is different than our 3rd round. But because we had so many interested parties, so many potential projects, we needed to consider the ones that made the most sense to the community. And so we reviewed those with the Affordable Housing Committee, and we arrived at a series of 7 that you're seeing here that are part of the plan. And those 7 are shown on this map throughout the community. And what I think this map helps to show is the distribution of those various projects. We recognize that probably the southwesterly area of Parsippany is experiencing a lot of growth right now for the former Matt Cali Corporate Center that was there, and many of the infill that has occurred at that location. So we then looked at other locations that were being offered and tried to distribute that need throughout the community wherever possible. So that is the map that shows that distribution. The last part of it is the plan summary. As I mentioned, we're addressing our rehabilitation share continuing through the Community Development Block Grant Program. And also, in addition to that, you'll see as part of this document in the appendices at the end of the document is something called a spending plan. The spending plan is a projection of potential income that's coming into your trust fund. And what we did in that document was to identify under rehabilitation funding to help fund a program to help existing residents in the community that would be income qualified for improvements to their homes for critical systems, whether it be plumbing, heating, electrical, or roofing systems. And that's something that we have a long track record of assisting our residents with. And it's something that we would help to expand upon. You currently have an administrative agent that would help to administer that program. That is a private consultant that's hired by the township every year. That consultant would be in charge of actually administering that program for rehabilitation. So that is how we're addressing affirmatively the 138 units of rehabilitation requirement. I mentioned again the prior round, the third round, that is all being addressed as we had talked about, the RDP as well as the prior round obligation. What is also being addressed and is part of our current plan, it's still remaining in the plan, is to address our unmet need. We have 469 units that were remaining from the third round that were not affirmatively directly addressed by RDP. So we had put in various overlay zones that exist currently that we're looking to maintain. And I'll turn to those now. And what I've done is provided this map which shows you where the various overlay zones are. And in the total, on the columns that you may not be able to read from a distance, but it shows that we have affirmatively addressed from the prior round approximately 303. It's probably closer to 350 at this point of potential units to address unmet need. The reason why I say potential is that some of them have not come into fruition, but they're not required to come into fruition for the third round or an actual round. You're just to show you've done your due diligence and established your zoning to address that need. And so those mechanisms are going to remain in effect and remain in the plan. And so that would be another way of showing that we've affirmatively addressed the unmet need. In addition to that, what isn't shown on this map is that we do have mechanisms that we've adopted in the third round that are part of your existing zoning. There's a mandatory set-aside ordinance that your planner is well aware of that is required of any development that's 5 or more units that isn't forecasted within our planning, that has 5 or more units, that one of their units, or 20%, has to be affordable. And so that is to capture any unforeseen developments that may come before these boards, whether it's this board or the zoning board. And so that is captured units already for unmet need through the zoning board. In addition, lastly, what I'll talk about is just where we are right now, is that we're at this point of having this board, I said land use board, I apologize, it should have been planning board, to adopt the housing element and fair share plan. That is what I'm offering to the board this evening. We are having this hearing tonight in order to adopt this document. If the board does find affirmatively that it is an appropriate plan to adopt, it is a very strict time frame by which, I'll charge Dustin with this, that we have to submit it by 48 hours in order to have the plan considered by the program. They have that actually in the state law, that we have to submit it that soon. In addition to that, after this plan is adopted, the mayor and council would be asked to endorse the plan. And they would also be asked to consider the spending plan as part of the document, because this board really does not review items of where funding is spent. It's more of the role of the governing body in order to do so. What it's provided for in this document is to show how we have affirmatively addressed it, but yet ultimately it is adopted by the mayor and council. Then we enter that challenge period between July 1st and August 31st, and then after that, the next schedule would be March 31st of 2026 would be the next step, of which we would then look to formalize what is in the housing element fair share plan. And so with that, Mr. Chairman, that concludes my direct presentation to the board. I will turn it back to the board for review and consideration of any questions.
Counselor, you have anything to add?
No, I don't think so. I guess just the only thing to add, in the world where there are challenges to it, there is a period of time when the parties, whoever does challenge it, could meet to work out whatever those challenges are, whether it be revisions to the plan, which would occur realistically sometime in the fall. And then I guess just speaking to the timelines real quick, and I know Ed had mentioned that they were very truncated. I think it's important to note that the statute indicates that every municipality, in a world where you were challenged on your numbers, so that occurred in the spring or winter, whatever you want to look at it, that the program was going to render a decision by March 30th. Well, whether they rendered a decision or not, no one received them on March 30th. They just finished their mediations at that date. We received ours, or the township received its judgment on May 13th. So 45 days after the statute said everyone would receive it by, that was kind of the par for the course. That's, to some degree, the courts don't have to listen to the legislature in that respect. So just to give the board another example of the very truncated timeline of not actually knowing what the number was going to be, whether we were working with the 553 number or 496, that wasn't solidified till, middle of May. But I think with that, I don't have anything else to add.
All right, the members of the board have questions. Michael,
Or comments?
all of the above.
Okay. I have two comments and one question. I really don't like increasing the density in Park. I know we're under the gun here. I'm gonna support it because we're under the gun. But increasing that density is a very bad idea, in my humble opinion. The other one I would be concerned about, is the lumber yard. That's a very complicated traffic pattern now. As its current function was as lumber yard, it did not give us a problem. But if it's going to be residential, entrance and exits from there, from apartments, I don't see a solution there. That whole area would have to be totally redesigned.
Yep,
To something else to make that work.
absolutely.
So those are my two concerns. I know you're under the gun, I would support it. I'm really concerned about those two. The other one is, maybe, this is a question for you, Dustin.
Mm-hmm.
We're talking about this agency that, investigates the people for their incomes, determines who's going to move into them. You know, in the 40 years I've been on the council, I have never seen a report from this agency as to who's moved in, who's moved out, how many they're keeping track of. Not a single report has ever come from this so-called agency. Does one exist? We're paying one, I know. I see it in the budget. But I have never seen a report from this agency. Have you, Jamie?
No, that's the administrator, our administrator, so we have to actually, I forget the administrator, it's GH,
CGPA.
yeah, JCP&H,
They
so,
should be giving us annual,
yeah, because
quarterly.
they're the ones that do the, backgrounds, they're the ones that do they're the affordable housing administrators of the township.
They do the backgrounds for select projects. You may have a developer opt for their own administrator of the affordable units. And there has to be a monitoring report that's prepared that assigns how they've been monitoring the actual units themselves.
The mayor and the council should certainly be reviewing that.
Well, we should,
We still can-
if it's a private, if they use a private administrator,
They still have to report.
They
yeah,
still have to
okay,
report.
good.
Yeah.
So we'll have to,
We've never seen a report.
that's fair.
And that's something
We'll check with our administrator, and then we'll see which ones don't
At the very
conform with the
least, it should be
township.
quarterly. I think they should be monthly, but at the very least, quarterly reports.
I will also mention that the Fair Housing Act, in an attempt to try to address that issue, is now asking for all these administrators to report directly to DCA. And there's now monitoring at DCA that's being done as well.
Good.
Okay, so start. Questions of,
I have some. Oh, real basic question. Lanadex, now Park, Lanadex, which is now Park, when we first voted on that for the third round, it was unmet need.
Right.
I thought, okay, and I know you showed me this. I guess I'm having a little confusion with what unmet need is. And I know now, I guess you put some of that toward the third round to help meet
The
our
actual-
numbers.
Correct, right.
And if we do more building there, we're going to use that for the fourth round.
Correct.
So what is unmet? Why is unmet need in a separate category?
Unmet needs in a separate category, and I can understand it's a good question. I can see why it's confusing at Park, because it's doing both elements. First off, it started as unmet need, a mechanism to address unmet need. And the reason why it started off that way was, at the time, it was not deemed clearly when they were going to start doing their development. We went through discussions with them, with the court master, and the court master actually decided and said, look, we're going to assign you to unmet need. We don't feel you're going to be appropriate for RDP at the time. It's been proven that they have, in fact, were
It
serious.
was the first
and moved
project
forward.
before all the
Exactly.
other third projects.
Exactly, so they proved this wrong. But there still was a requirement to address part of what's called your unmet need, because your overall need was so high. It was 1,314 units in the third round. That 1,314 units was reduced down to the 800 units, but yet there is still a requirement under the rules to show that you're looking to put in some mechanisms to address that unmet need. And Park became that, one of the mechanisms to address that. And so that the reason why it wasn't originally part of RDP and solution is because they weren't clear on when, in fact, they were going to be starting. And sure enough, they have started. So we took benefit from that because we had those two projects that did not come to fruition. And now our regulatory because of regulatory changes, are no longer applicable to address affordable housing. And they've actually sent us letters indicating that on Edwards Road, those two projects.
Yeah.
And so therefore, we were able to assign some of the credits that we fortunately received and are constructing at Park Lanedex
Good.
in order to assign
Yeah.
to those credits.
Another thing is and I was trying to look for it because I did see it before I came here, that quote you read after talking about the Highlands conformance, about developers they're interested in projects that have to do with community, low-income housing.
Right. Think of it as an inclusionary housing.
Inclusionary housing, which is different than, I guess, yeah, so, I mean, all of these people aren't they? So what's the significance of that being different?
Yeah, the inclusionary housing part of it is that they've identified under the rules, the affordable housing rules, that in order to incentivize development to build affordable housing, because they're really not making any money on the affordable units.
So that would be like one unit with a lot more than 20%?
No, they're saying that you should allow them to build 4 units for every 1 unit.
4 high income for every 1 low income.
Right.
Yeah.
And that way they subsidize through that density bonus.
But that's in our master
The affordable
plan,
housing.
isn't it?
Oh, it is in our master plan, yes. Affordable housing is in our master plan, and that's one of the goals and objectives that we're furthering with this document. But
So, like, I guess that's not everywhere.
no, it's not everywhere, and that's sort of the result of the Fair Housing Act. It wasn't everywhere, is what I was
Okay.
saying. It has been part of our master plan because we participated through the various cycles, and we put that in there because it was required in order to maintain conformity with the Fair Housing Act.
Okay, thank you for answering my simple questions. Your presentation was great. Thank you.
Nick, did you?
Thank you. Thanks. Awesome. In the book too, I learned so much just going through it. Appreciate it. I'm happy to see that no trees are going to be cut down. It's always going to be something that's already there, established, and we're knocking something down, and I'm happy with that. Okay, so whatever we decide tonight, which it's for by tomorrow, or something, you have to send it in by tomorrow?
48 hours from tonight, yes.
So that means that for the next 10 years, we have these 496 to build.
You have zoning to put into place.
Not like it's got to be completed by 2035. It has to be just approved.
The zoning has to be in place. That's really your obligation.
Okay.
When we get to 2035, I probably won't be here, but at the same time, whoever is, we'll be looking at your plan and saying, okay,
I
what
probably
didn't
won't be
come
here
to
either.
fruition? What is not realistic anymore that
Right.
maybe didn't come to fruition? And may change the zone plan then in order to address that. But yet, at this point, we're forecasting for the next 10 years. They've all indicated that they're willing developers and willing to do this project for the densities that they've asked for. And so therefore, we feel that they're appropriate.
Okay, so then if let's say there's one of those ones that has a high number in it, and that company goes bankrupt, this one in Park Lanedex, just throwing it out there, we lose those 60 affordable units.
As a hypothetical.
So how do we pick up another 60 then?
You would then, we have to then also, I didn't mention this, there would be probably a midterm reporting to the court, so in 5
Okay.
years. After that 5 years, something of that occurs, there's a bankruptcy, there's a property that has maybe some environmental constraints that weren't thought of at the time, and it needs to change. At that point, we may have to amend the housing element fair share plan.
Okay, and then one that I guess is more personal than anything else. There's already like 7 projects being built that are all, eventually the kids are gonna go to Parsippany Hills High School.
Yeah.
And in this proposal here, there's 6 more out of 7 that are Parsippany Hills High School. And it looked like these other builders who proposed something, which you guys said, nope, not necessary, fine. It would have been more balanced. 3 for the high, 4 for the hills. So I'm just concerned eventually, I mean, what's Parsippany Hills High School gonna look like? You got, I think it's like 2,000 units total on this side now, plus whatever's coming here. So I just want to know how come it wasn't more balanced for the high school purposes. 287 splits our high schools.
Understood, understood.
How come it went 6 out of 7?
It had to be balanced based upon also distribution from traffic standpoint as well. We needed to consider that factor. Also needed to consider where properties were being redeveloped already. So we did include those. Certain properties that made sense from a planning standpoint. Certain properties that, like you had mentioned, may benefit from additional greenery due to the fact that it's currently all macadam coverage. So after weighing all those factors, that's how we considered it, but yet, at the same time, it's understood there's going to be impacts to the schools. And that's extremely unfortunate, and that's unfortunately something that, as the rules have been established, as well as the courts in litigation have said, sorry, that's not what you need to consider when you consider affordable housing. So unfortunately, I wasn't able to use that as a direct tool to try to sway and decide where things go. So,
All right, thanks for the explanation. Appreciate it.
thank you.
Okay, other members?
Yeah, well, I was part of that committee, and of course, there's a lot of painstaking going through this whole process. Town's a big town, and I want to address this one thing, Ed, because we did have discussions based on unmet needs first, the current round, and why we couldn't meet those unmet needs, and then it made a lot of sense because we had a lot of interested parties. We couldn't ignore it. We couldn't ignore the fact that we had to address round 4, and the reason why we had to address round 4 was because, and you know, Tom, there was so many interested parties that if we would have ignored it, we could have had litigation against us. So it's one thing. This is the criteria to where we got to tonight, and I didn't want that because I will tell you, litigation never goes well for a town when it comes to affordable housing. It just doesn't, and I know this seems like it's the last minute because this is how much time we put into it to make sure we got it right the first time. Now, let's talk about the unmet needs, and I understand it more now. Ever since we had these meetings, we had, I think, 300 units that were supposed to go where Mount Arlington Plaza is, and that came to 63 units, I think, right? That makes it an unmet need. You still have to, I just want everybody to understand that, you still have to, even if a developer decides not to build, well, you still got to meet those needs of that affordable housing, and that's where that 63 came in. I know there's a concern about, you hear Cerebros, this and that. Well, they still got to go through the process. They still have to have traffic approvals. They have to have DOT approval. They have to have all those things set in place that we don't get to determine, but the state will determine. And so that doesn't mean we take them out of that we take them out of the role to do it. They still got to meet the criteria. They still got to meet those types of things. I tell you, unfortunately, in the recent years, nothing thoughtful has come out of Trenton when it comes to affordable housing. Not one thing. It's like they don't care about suburban Jersey. They just don't. They make these rules up, and then, as you know, you have one Democrat senator who fast-paced this. Jammed it down the township's throats, not just Parsippany, just jammed it down our throats and saying, these are your deadlines, when we didn't have those deadlines prior to when they put this bill in. And this is the bill that we have to now face, we have to deal with. It's a shame we have to deal with it, but it doesn't address water, it doesn't address schools, it doesn't address traffic, it doesn't address any of those things. Because in Trenton, they don't really care. They call it affordable housing, I call it high-density housing. That's what they're ramming down our throats in Trenton. But it's mandated. I've been on the other side where I've seen towns that were going to fight it. I left that town, and now they lost their immunity. The last thing I want in Parsippany is the courts to decide where the housing goes, because we lose all control of our planning and our zoning boards. This is why the plan that we're putting forward today, in my opinion, is the best plan that we could put forward. I want to thank you, Ed, for all your work. I know it was a lot. you know, sitting with you sometimes, you're like a sedative, you could put me to sleep, but that's okay. Dustin, I know you got a lot of phone calls from me, I had some concerns, but, I think, you know, you're gonna get your 48 hours to answer this thing, because the last thing we wanna do is lose our immunity. And I know some of the board members, you have concerns and stuff, but this, you know, this is a plan that is gonna, you know, next 10 years, and like you said, whatever's not met becomes an unmet need. So hopefully I'm still the mayor to 2035, but I don't know, that's a long time away. But, you know, there was a lot of work. I know, Tom, you and I had a lot of conversations about this. This is the last meeting I wanted to have, you know, but we have to address it. We can't run from it. That's the bottom line. You can't run from it. You can't hide from it. This is the mandated, and it's mandated, and I say that for a reason. Because the state mandates it, but of course they don't give us any funding for anything. And as you know, our water capacity, only because we built 2 new wells over the last 3 years, and if they recommend we build another one, we're gonna have to build it. Because, you know, if we want to have any commercial industry come in here, we have to have this resource for water, so. Thanks a lot, gentlemen, I appreciate it.
Anyone else have questions over here? No?
I would just like to thank Ed for his work.
You're welcome.
Ed is always, I've been dealing with Ed for what, 30 years now? You are always very thorough.
It's hard to say that.
Yeah.
Thank you.
I do have a question, and that is that even though you talked about the improvement in the water, was there any study done of the aquifer?
No,
All right.
it's just on capacity.
I'm extremely concerned about that. Human beings have a long history of overdrawing aquifers, whether it's Las Vegas, Oklahoma, or even Carthage in Roman times.
Hmm.
So this is something that I would love to know. I mean, we may very well have plenty of capacity, but I don't know it. We could wake up one day and the mayor's sitting there telling everybody they gotta stop drinking water because we don't have it anymore.
Don't talk about Flint, Michigan.
You talking about our water resource?
Yeah.
Oh, we did a study on that back in 1984. Elam and Popoff were our experts then.
That's all.
And we determined that with our artesian wells, they're 600 feet deep. With our artesian wells, we had enough water to provide for all of Parsippany's needs, even if every piece of land in Parsippany were developed. Now, that being said, okay, then 10 years later, the courts came around, the state came around, and they says, you can't pump all that water out of the ground, because that water is underground water. It comes from probably the glaciers, but then it feeds other towns.
Right.
So if we draw too much, the other towns don't get any water. So it's the government that's limiting the water we pump out, not whether we have enough in the ground for us. They limited us.
Yeah, we
And
can
then they
only,
also required that we have an alternate water source.
Yep.
So we have to buy, how much, a million
I
gallons a year?
forget, we have an agreement with Jersey City.
We have to buy, well, I think it's 100,000
Yeah,
gallons
something like
a
that.
year. Whether we use it or not, we have to pay for it.
And that
So-
satisfies our allocation.
So everybody, in Lake Hiawatha and down to where I live in Parsippany, okay, the water tank on, near the reservoir, every so often, our water department sneaks some Jersey City water into that tank. And I get up in the middle of the night to get a drink of water. I get the glass near my nose. I know it's Jersey City water. And for a couple of weeks, I have to go to bottled water. But we're the only section in town that gets that Jersey City water. Local complaints.
Well, let me just,
Tom, can I just add one more thing, and, because I gotta deal with it more than anybody, and I'm gonna make this statement loud and clear. Pilots do not affect the schools whatsoever. Because I'm bringing this up for a reason, because more kids go into the schools. Pilots don't bring kids into the schools. It's projects like affordable housing that do. That's the difference, and I want everybody to understand that. you're gonna hear in the future, pilots bring school-age children. No. Housing, residential, that brings school-age children. A mandated high-density housing brings school-age children. Pilot or no pilot, it does not increase the school population. I just want to make that clear.
And the other point you should make is the school board does receive the land tax.
Right.
Right.
So if it's an empty office building, the land tax is the only source of income. So whether it's developed or not, they get the same amount, the land tax.
Well,
Your turn, Tom.
I am not a fan of Trenton taking away home rule. I am not a fan of Trenton mandating urban sprawl. I am not a fan of Trenton not providing us with the resources we need to handle the traffic that is going to be generated by this. I am not a fan of not knowing what our real natural resource constraints truly are. All right? I think all of this, if we're going to do something like this, Trenton should be on board with doing a complete census of what all of our requirements are, whether it's traffic, regional traffic. I think we have a regional traffic problem right now. It is difficult for me, except for the fact that it's been made very clear that the alternative is worse.
Yeah.
That's, I'm having, I'm gonna vote for this. I object to it. It's a brilliant piece of work on your part, but you had constraints you had to work within. You had courts and mandates that had to be met. Okay, what management in the world doesn't have to deal with that anyway? But those are my objections. That's where I stand on this. Ed, you've done a fantastic piece of work here. And Mr. Mayor, I have to applaud all of the work you're doing to get him and to get this whole plan together, because you had to lead for this.
Thank you.
And I appreciate that. So,
Here's what I will say, Tom. You don't mind building affordable housing units if they're for your residents.
right,
If they're for your individuals that work here in the town, that, labor in the town, but it's not. And the process is just, it's an unfair process, but that's what's mandated, and that's what we have to, abide by.
if I were going to Atlantic City, I would actually bet that by 2035, we will have overbuilt. And the reason we will have overbuilt, one is the reduction in the birth rate, but also more importantly, the reduction in the immigration allowed. And if that immigration is continued at the current level, I really think that we're going to find that we have too much housing at that point in time. We have too little now. We need more. But we will have too much if this all goes through. That's my opinion. I'll probably find that it's different in 2035, but that's,
It's probably correct, because we did the same thing with offices.
Yep.
Yeah. Big demand for office space. So we built lots of offices. Now we're tearing them down, we're building apartments
And warehouses.
and warehouses. And what are we building in 20 years? Something else.
yep. Now, I'm just going to turn to my professionals here and find out if there's anything they want to say before I open it up to any public comments. Do you have anything to say, Andrew?
No.
No, and did a wonderful job on the report. I have nothing to add.
Thank you.
Okay. Are there any members of the public who have any comments or questions on this at this time? Hearing and seeing none. What else do we need to do?
Make a motion?
Yep, motion.
Do I have a motion?
Well, the wording for the motion will be to accept this current version of the housing element and fair share plan.
think that's
To adopt,
sufficient,
yeah.
yep.
Either way.
To adopt.
Yeah,
To
to
adopt.
adopt formally.
Yeah.
To adopt.
Do I have a second?
Second.
Thank you, Jigger. Nora, would you call the roll, please?
Mayor Barbario.
Yes.
Mr. DePiero.
Yes.
Ms. Hernandez. Yes. Mr. Mealy.
Yes.
Mr. Napolitano.
Yes.
Mr. Shaw.
Yes.
Chairman Dinsmore.
Yes.
Ms. Smith, did I miss you? You missed me, it's okay. Ms. Smith? Yes.
All right. Is there anything else that needs to come before this board at this time?
Motion to adjourn.
Yeah.
Do I hear a second? All in
Second.
favor, say aye. Anybody opposed gets to stay here. Oh, my. And you came here?
I know. On Saturday.
Congratulations.
Thank you. Yep.
Good luck with everything.
Exactly.
Unless you want to pay $7.
Yeah.
It is